But fortunately and thankfully, the plaintiff, Ms. Silencio, has made a good recovery. And that's all I have to say, because as the jury looks at what I have displayed here, of course, the doctor's already given sworn testimony in the case. And this is what her doctor said, so I don't have to make the case. I can simply say, you know, this comes from the plaintiff's treating doctor, who's already given sworn testimony in the case, and that'll be played for you. It's on video, and it's his opinion that she has no ongoing health problems, fortunately, that she has no long-term harm or effects, and he says that in his opinion she's going to do fine, thankfully. She last had to go see the doctor 5 years ago. And from that, I can talk a little bit about sympathy and how, you know, everybody certainly feels sympathy when somebody's hurt, but remember what the judge said a few minutes ago, that while we all have that, that's just not a part of this process. It's not a part of what you're here to do, to objectively and impartially scrutinize the evidence and render a just verdict. So that's one way for me to say, you don't have to believe me or listen to me. This is from the doctor and they can see it. Maybe seeing might be more believing, so to speak. And then I can talk about what the law requires, because I probably have not heard too much. As you sit out here, think to yourself a minute, you probably, in these trials that you have, you don't hear plaintiffs' lawyers talking too much about the law. I don't hear them talking about burden of proof or proximate cause or the legal standard or anything like that. In fact, in this case, plaintiff's lawyer had so-called safety rules that were inconsistent with Georgia law. So it gave me the opportunity, and this was a companion case to a death case that arose